moved up in the popular education block, the district of Nagaon, whereby the district elementary education officer by order dated inquiry in the by district elementary Nagaon by order 30/12/2017 allowed the respondent number 5 to be the president of the SMC of the state. As per the provisions of the right of children, Assam right of children to free and compulsory education rules 2011. Period of a school managing committee of such elementary schools is for 3 years. And said order of the DEO Nagaon period 30/12/2017 have already spent its force in beauty of this certificate. The interim order passed earlier on 11/04/2018. He has been promoted or what? He has been promoted, Mr. Counsel. He has been promoted or what?
No, my lord.
What happened?
I was not released earlier, my lord. That's why I filed this petition, my lord. I was transferred, my lord.
While the petitioner was serving, petitioner is a sub-inspector of schools, and while he was serving in the same capacity at Suksar Circle, Mankachar, district South Salmara, the state government in the elementary education department by notification dated 21/04/2017 allowed him to hold the charge of block elementary education officer Mankachar under FR 49C. Subsequently, by another order dated 23/03/2018, the Deputy Commissioner of South Salmara Mankachar Mari Sri Emmy Loskor, Assistant Commissioner Hatsingimari, was allowed to take over the charge of BEO Mankachar, Elementary Education Block, from the petitioner. Being agreed, he preferred the state petition. In the meanwhile, the petitioner has been transferred as an SI from Luxor Circle to another place. In view of the above, the state petition being certain dismissed. The interim order passed earlier on 28/03/2018 stands.
Last. May I please, your lordship? My lord, this is an old matter, my lord, and perhaps, my lord, instruction is required that whether the entire posts for these categories has been filled up or not, my lord. And as there is no interim order is operating, this is, my lord, regarding the appointment of instructor under the Dr. Banikanto Kakoti Computer Literacy Program, my lord. My lord, may in the secondary department, my learned friend may obtain instruction regarding the status of the selection, my lord.
Mr. Somo, are you appearing in this matter?
Yes,
On behalf of whom?
Madam, respondent of 5.
University Grants Commission, my lord.
What is your stand?
My lord, sorry to say, we did not receive the copy, my lord, yet. That is why respondent number 4, my lord, I have not been able to take any instruction. Perhaps, my lord, it may be infructuous, my lord.
Let us. Mr. Sharma. Fine morning in the week. Don't say no instructions. Tell us what is there for you.
He also doesn't have a copy.
In this matter, instruction is required, my lord.
And ask the officers to
We have,
come
my
here.
lord, no copy.
By 12:30. Ask them to come here. Ask them to come. That will be the best solution. They will bring the solution. This is a matter of 2018 and the notice was issued on 9th of April 2018. 5 years. Tell us what to do.
Telephone.
Initially, I'm allow for this. It's not a practical.
Bolo, some. Take your seats.
Number
9.
59. is a so certification happy. This is a
Mr. Ayavia, counsel appearing for the petitioners. Also heard Mr. U. Sharma, standing counsel, Department of School Education, for the respondent numbers 1 and 2.
One.
Who appears for
Three.
RMSA?
RMSA not present.
Mr. B. Gogoi, standing counsel.
Could go.
Or P. Nayak, who appears?
B go. RMSA no.
RMSA. Respondent number 3. And Mr. A. Sumo, standing counsel UGC for the respondent number 4. The Director of Secondary Education, Assam, on 26/09/2017,
Yeah.
More than 1 hour.
issued an advertisement for filling up of 3052 posts of computer instructor under the scheme of Dr. Banikanto Kakoti Computer Literacy Program in the government/provincialized high/higher secondary higher secondary schools /high /senior madrasas /senior secondary schools /Arabic colleges, local body schools for implement of ICT enabled teaching learning facilities towards initiation of a comprehensive computer education program. Pursuant to the same, the Director of Secondary Education, Assam, conducted the selection on 26/02/2018. The state government selected in phase manner issued the select list for appointment of computer instructor in the concerned educational institutions in terms of said advertisement dated already. The respondent, the petitioners filed this petition on 05/04/2018 praying amongst others not to fill up the vacant post of ICT computer instructor as advertised on 26/09/2017 without publishing the complete select list, and to direct the respondent authorities to publish the remaining list of candidates. Some other candidates for the post of ICT computer instructor advertised on 26/09/2017 approached this court in WPC number 1425/2018, being agreed with such action on the part of the respondent authorities in publishing the select list for those 3052 posts in a phased manner, wherein the court by order dated 23/03/2018 in said WPC number 1425/2018 observed that the declaration of select list in phase wise is impermissible under law, as in such eventuality an arbitrariness could creep in. Accordingly, the court by said order dated 23/03/2018 directed the respondent in WPC number 1425/2000 directing the respondent authorities to publish the whole of the select list at one go and refrain from acting upon any phase-wise list that may have been published in the meantime. On perusal of the records of say WPC number 1425/2018, it is seen that the state government, the education department, placed before the court that out of those 3052 numbers of post of computer instructors, the concerned screening committee that was constituted for selecting the candidates after due verification of the documents and other relevant materials for selection of the candidates in the first phase found 1130 numbers of candidates eligible for appointment to the post of computer instructors as advertised on 26/09/2017, and that before filing say WPC number 1425/2018, those 113 numbers of computer instructors were appointed on 26/02/2018 itself. Next. The said screening committee, after further verification, found 255 numbers of eligible candidates for placement as computer instructors as advertised on 26/09/2017. Considering interest of the matter, the court disposed order.
My lord,
It was already disposed of
my lord, my lord.
by order dated 08/08/2018.
Similar.
Directed the respondents in the secondary education department to publish the list of eligible candidates for the remaining 1922 numbers of post of computer instructors in one go pursuant to the said advertisement dated 26/09/2017, and also to publish the list of 1130 numbers of candidates who were already appointed on 26/02/2018 as computer instructors, clarifying that unless such list of 1922 numbers of candidates of computer instructors are duly published, the respondents shall not fill up the remaining 1922 post of computer instructors as advertised on 26/09/2017. The court in the said order, the 08/08/2018 also observed that the respondents in the secondary education department shall complete the entire process of selection as expeditiously as possible, preferably within a period of 3 months from the date of the said order. Since it is repetition, considering the above, the court is of the view the prayer made by the petitioner Seniority has already been taken care of by the order dated 08/08/2018, passed in said WPC number 1425/2018. And other connected cases. There are many cases disposed of on that.
My lord. I filed more than 3 petitions.
There are many.
It's
Obliged.
disposed of, my lord.
My lord, highly obliged. my lord.
For the instance disposed of.
May it please, sir, Lordship. Lordship may kindly pass the matter for the time being as my senior is on legs in court number 1.
Where is Mr. Khatani? What's your good name?
GK Gogoi.
Counsel for the petitioner. Petitioners. Pardon, Mr. B. Counsel, Department of School Education for the response number 1 and 5. No representation on behalf of the counsel for the respondent numbers 2, 3, and 4. The name of the standing counsel's findings have been reflected in the cause list. Matter pertains to reduction of pay. Mr. P. Sekal, counsel for the response number 4. Government Advocate Assam for the response. Of trained graduate teachers of LP, junior basic, pre-primary school teachers from rupees 8,700 to rupees 7,400. Notice in this case was issued on 03/09/2018. And the order set reflects that on numbers of occasions
My lord, may I
time were granted.
submit one thing, my lord? Issue is pending before the division bench, my lord. We have filed an affidavit. In fact, it was lying before your lordship's bench along with the review application. Lordship will release it because my lord, this is a 309 amendment. Now it's pending before the division bench, my lord. That affidavit will cover otherwise. But the LP school, LP school teachers.
Division bench order against the single bench or what?
No, my lord. Since my lord, the challenge was to ROP.
Because of that.
Yes, yes.
So B was standing counsel family.
I can serve a copy, my lord, of that affidavit to my learned friend, my lord, if required.
That
Stand is
issue
very clear.
involved in this petition as was amended. In the notification of this was under Article 309 of the Constitution of India, presently pending before the Honorable Division Bench. Do you have the retable number?
No, my lord, WPC number I will
WPC
provide.
number.
I will provide.
WBC number such and such. In view of the above, the registry shall list this matter after disposal
Lordship.
of said WPC number such and such. First of liquor. The petitioners also may make a mention of this matter after disposal of said such and such.
That notification is my lord 4th of August 2018. No.
Ma'am, please, Lordship. Lordship, matter regarding non-provincialization service, Lordship. Lordship, may kindly see the order dated 1/12/22. The respondents were directed to file affidavit within the specific time frame, Lordship. Till date, they have not filed any affidavit. On the last occasion on 17, the matter was listed. They have taken time till today. But no affidavit has been filed. Almost 2 months were granted to him, the Lordship, to file affidavit. It is a 2019 matter. Some has already attained the age of superannuation.
My lord, in this matter, my lord, as the issue involves, my lord, whether the drop teachers, they can be given the effect, provincialization effect from 2013. Now, act being struck down, my lord, this issue, my lord, our opinion has been sought from the Advocate General by the department, my lord. So, Lordship will take up after 2 weeks, my lord. In the meantime, I can. Otherwise, the moot question is, my lord, when the 2011 Act, once it has been struck down, my lord, can they get the benefit under the struck down Act? Because 2017 Act, my lord, the saving clause, it has been given protection to only those teachers who were provincialized prior to the judgment, and their cases will be reviewed under the 2017 Act. Basically, they are claiming the benefit of Section 4 of 2011 Act, deemed provision.
This section 4 was held illegal, Lordship, while striking down the 2011 Act. Otherwise, they can be Lordship considered under 1977 rule, Lordship, because they are neither come under 2017 Act, because 2017 Act relates to provincialization of Hansard educational institution, whereas our Lordship schools are already provincialized, and we are working in the schools. If not 11 or 17, then we may be considered against the old Act, Lordship.
Mr.
My lord. My lord.
Do you have the act with you?
My lord. $2011 Act. My lord.
Section 4,
Deemed provincial.
subsection 2. Giving provision is very clear. It doesn't matter.
The
Read
numbers
section-
of employees in both teaching and non-teaching cadre in each venture educational institution, services of whom are provincialized or to be provincialized under this Act shall not exceed as specified in the schedule appended to this Act, provided that where number of such employees serving in such venture educational institution exceeds the number as specified in the schedule, the provincialization of service of the employee shall be based on the basis of a seniority in respect of the category in the concerned educational institution. The state government shall not have any liability whatsoever in regard to such excess employed, provided further that the state government shall have no liability whatsoever in respect of any past liability of the venture education institute whose employees have been provincialized under this act.
Now, in terms of this, whether the schedule was under challenge by anyone?
Yes.
Schedule, it was under section
was a-
4, 2 or 10. Was it under challenge anywhere?
In the Chandanlok case,
Chandanlok case
Chandanlok
was-
case,
The schedule was what? Challenged,
it was challenged. The entire act, there are
That
several
is right.
provisions of
Yes.
the act which was
including the,
the schedule.
but the court found that it is an act having some false under the constitution and declared as ultra virus, right?
True.
In that circumstances, what will happen?
My lord, usually, my lord, as once the act is being declared to be unconstitutional, my lord, any order, anything done under that act deems to be an unconstitutional.
That
Now-
day, probably Mr. Gogoi have placed a decision of the Honorable Apex Court.
My lord,
The Supreme Court in that matter have also held when the act is found to be ultra virus, any appointment given is bad in law.
absolutely. In fact, my
In
lord,
that case, the decision of the Honorable Division Bench will also go because that deeming provision. Enter act goes, Supreme Court decision is prior to the order of this court. It becomes something else. Right? If it is so, how can you have a decision? How can you have a clause in the 2017 Act?
my lord, in
to
view of
consider
the
that case?
My lord, in view of the order that was passed in the review petition, my lord, because once the act is declared unconstitutional, it means, my lord, anything done under that act is unconstitutional. My lord, as the High Court doesn't have the power of the prospective overruling, and it is only the Supreme Court can say. So a review petition was filed, and there a liberty was sought from this honorable court that until the new act is being enacted, the person who has already been provincialized, they will be given a protection. And in the 2017 Act, my lord, if you're watching, will see section 24 once for a while. Section 24 doesn't give any right to the person who have already been provincialized. Their provincialization will be given a effect only after the review is being done under the 2017.
Where in 2023, when you have started that review,
Yes.
My lord, there is a communication from the director to the commissioner, my lord, which we place it before the division bench also. When the 2017 Act in its matter which pertains to challenge to the 2017 Act, where the applications were called, the communication says that the commissioner was asked to instruct to start the review process. Well, that process is not has ended,
not yet initiated.
not yet ended, my lord.
Why are you saying?
My lord,
Initiated?
my lord,
That review proceeding has been initiated?
No.
Yes, it-
instruction has been sought from the government.
So the
for-
process has not been initiated. Only the official file still in cold storage.
Hello. So that we have not also put an end to the review process. So be that as it may, my lord, and this in this writ petition, what they're claiming is they're claiming a benefit under the 2011 Act, which has been struck down.
If Lordship, I am not eligible under 2011 or 2017, and under 77 Lordship.
So you have
We
not
are,
been
we
you
are
have not been
special,
provincialized under 77 Act.
we are special category of Lordship, sir.
Is it the judgment? You have a copy of judgment
My lord. Exactly.
by which the court have.
Lordship,
Honorable
next
Apex Court
law.
have held that,
Sandan next.
no. The Apex Court judgment.
At page 59 of the judgment in our petition Lordship, in the Sandan judgment, it is para 10 Lordship. It is specifically stated regarding 4 Lordship, section 4.
Para 10 is the submission which was made by the-
Submission, but it is a live lordship.
Constable, can we
While
see
citing
the
down the.
para 2 of the petition for a minute?
Put police. This one. We'll have it next week.
Well,
Ask Mr. Gogoi to give the judgment. It was there.
I'll,
Yes, ma'am.
Council for the parties list on 9th.
Lordship.
9th of March.
Next, your lordship.
May I please, your lordship?
Hmm.
So this matter is pertaining to, we have challenged the order dated 25/3/2019, your lordship, which is regarding the promotion to the post of headmaster, your lordship. Respondent number 3 has issued a order in which the private respondent has promoted to the post of headmaster, whereas the petitioner is the senior most teacher, your lordship, and appointed as assistant teacher of Rainadabri High School on 3/7/1993, your lordship, and subsequently provincialized on 21/8/2013. Lordship, the Rainadabri ME School and High School are amalgamated on 12/11/2018. No. Your lordship, petitioner has all the requisite qualification as well as experience, your lordship, and he is the senior most teacher in that high school, and he was acted as in charge headmaster also, your lordship, for few years. Lordship may produce annexure B, your lordship.
Affidavit has been filed by two, respondent number 2, 3, and 4.
Your Lordship, we did not receive the affidavit yet.
Yes, you have decided to promote teachers of that particular school following the 2003 rules, right? Kindly come to paragraph, the rule 24 that is of 2003 rules. Because during the time of selection, this 2018 rules was not in force, and that 2018 rules came in 2019. So here you have to determine the seniority on the basis of receipt of graduate scale of pay. But there is something else in it. Read 24.
Seniority of a member.
Then please come to sub rule 3 of rule 24. Because this is 2003 rules.
Seniority of a member.
Can we read?
The seniority of a member of the service in a cadre who joins in a school otherwise than by direct recruitment on transfer or otherwise shall be determined as per the date of joining in the school in the concerned cadre. If a member joins in the school through transfer from other school, the seniority shall be determined from the date of his joining in the school in the concerned cadre, and the seniority in earlier school or in the same school in a different cadre shall not be taken into account.
So as per this 2003 rule, there is only one mode of recruitment, that is direct recruitment. So time limit 15 days, within 15 days, anybody joins on appointment, that will be taken from the date of appointment. But if somebody joins after 15 days, it will be from the date of joining, not from the date of appointment. That is why rule 24(3) that clarifies that otherwise than by direct recruitment, otherwise than by direct recruitment. Then what will happen? The seniority will be there from the date of joining in the school in the concerned cadre. But if you see the 2018 rules, there the case is different because therein the Shiksha Kshetra scheme was brought in. But it was not there in the 2003 rules. Here the private respondent who has been promoted to the post of headmaster, no doubt, he received his graduate scale of pay from the year 1991, from the date of his appointment. And he was appointed as a graduate science teacher. So he was receiving graduate scale of pay.
Yes.
But he was under Directorate of Elementary Education. His cadre was different. Now after this amalgamation, he was brought under the secondary education. And he remained as science teacher in the graduate scale of pay. But from when? He born in this cadre of secondary when? Only after his amalgamation. Only after that ME school was amalgamated with the high school. In that circumstances, following the provision of rule 24(3), will he be senior? You cannot have to. If you are following the 2003 rules, then you have to follow the 2003 rules only. Got it?
Yeah.
So otherwise than by direct recruitment. So they will come under the otherwise category. That is transfer or otherwise.
Yes, ma'am. Service complete.
Yes, Trevor, what will do? Tell us. In that, following that provision. This goes. Is not it? But if you read the 2018 rules, you'll see there's something different. Read 2018 rules. There, things are different because that rule will not be applicable in the present case. Read rule 24, that is at page 41.
18,
Page 41
18.
of the new book. Page 41. And turn to page number 42. Read subrule 5 of rule 24.
In case of amalgamation of ME, MB, LP school with other higher secondary school / high school under the scheme Shiksha Khetra, the employees of the amalgamated school shall be given seniority with effect from the date of joining on substantive appointment or regularization, provided that in case of graduate teachers, the seniority shall be counted from the date of getting salaries meant for a graduate teachers. Provided further that in case of a contractual teachers, the seniority shall be counted from the date of absorption in the sanction post carrying regular time scale of pay.
So here they have clarified. If somebody is a graduate cadre, he will be senior. He will be getting his senior from the date of receiving his graduate scale of pay. As per the provisions of the 2018 rules, yes. The response number 5 will be senior to the petitioner because he joined in 1991, November 1991 and received graduate scale of pay. Whereas the service of the petitioner, though his service was provincialized only in the year, but the case of the petitioner is that he will be senior. He received graduate scale from 2013. Following this provision. When you have taken that decision, February 25th, came into force on 10th of October. Now, this 2003 rules,
Yes.
if you see, it's only meant for those schools whose services has been provincialized under the provisions of the Provincialization Act 1977. And it doesn't extend the particular (2011) Act or the 17 Act, the Assam Secondary Education Provincialized Service. Got it? Here, as per this 2003 rules, it is only 1977 Act.
Yes.
And this 2003 rules was not made applicable for any such schools and such schools provincialized under the 2011 Act or the 2017 Act. So whether the 2003 rules which you have applied here will be applicable. And if you want to make it applicable, because your decision was the BTC took a decision to make it applicable. but it was not extended. So that way also you cannot have applied that rule. Mr. Counsel, when the advertisement was issued for promotion, when
8/2/2019.
8/2/2019. Are you sure?
Annexure F, Your Lordship, page number 16.
Please read page number 19 of your petition.
It is a type copy, Your Lordship.
Kindly read. There is type copy or the next
is-
page.
It
When the
is,
advertisement was issued.
yes, sir. It is notified for general information to all concerned that the verification of academic qualification and professional qualification, that is B.Ed degree of graduate teachers who applied in response to the advertisement notice dated 3rd November 2018.
So when the advertisement was issued,
3rd November.
what was the last date? What was the last date? So the advertisement is annexure F, right? Advertise annexure F. Page number 16. Is it correct?
It is a notice, Your Lordship.
That is the advertisement. So
Yes.
you kindly read, though it is in form of notice, that was the advertisement.
Yes, Your Lordship. The BTC level selection committee shall hold selection for the post of
In
headmaster.
terms of this, the last date was 17th of December.
17th of December 2018.
Now see the clause D,
Teaching experience,
A.
minimum 10 years as graduate teacher for the post of headmaster. Ministers.
When your school was provincialized,
Page number 10. When?
2013.
2013. And giving effect from 1st of January 2013.
Yes, sir.
So whether the petitioner up to 17 December 2018 shall have 10 years of teaching experience as a graduate teacher?
No, Your Honor.
Will he have?
7 years. 2013 to 18, 5 years. Sir.
Got it. What is your good name?
Ardas, Your Lordship, on behalf of Jailers Court.
Heard Mr. Ardas, counsel appearing for, on behalf of Mr. Jailers, the counsel appearing for the petition. Also heard Mr. U. Sharma, standing counsel, Department of School Education, for the response number 1. And Mr. Standing counsel BTC,
2, 3,
for
and
the
4.
response numbers 2, 3, and 4. None appeared on behalf of the response number 5, though the petitioner served the notice of distress upon him by Justice Service on 20/01/2020, pursuant to the order of the court. Dated 21/11/2019. Please take your seats. The managing committee of Reindabari High School District Kokrajhar during its cancer stage appointed the petitioner as an assistant teacher who is a science graduate with honors. Pursuant to his such appointment, he joined the said school during its venture stage on 07/07/1993. The service of the petitioner, along with other education and other teaching staff, teaching and non-teaching staff, was provincialized by order dated 08/2013 under the provisions of the Assam Bhansar Educational Institution within bracket Provincialization of Services bracket close Act 2011 as amended during its course on being approved by the state government, the secondary education department, as well as the finance department of the state. After such provincialization, with effect from 1/1/2013, after when the regular headmaster of the said high school retired from service on attaining the age of superannuation, the inspector of schools Kokrajhar, district circle Kokrajhar, allowed the petitioner to hold the charge of assistant teacher of such and such to act as an in-charge headmaster of the said high school under FR 49C in addition to his own duties, and also allowed him to act as a draw and disbursing authority for the monthly salary of the teaching and non-teaching staff of the said school, enabling him to operate the bank account. As he completed his B.Ed, the Inspector of Schools, Kokrajhar, by an order dated 25/07/2017, allowed him to draw an advance increment for passing the B.Ed course with effect from 01/07/2016. Pursuant to the order of the state government in the secondary education department, Reena Dabri ME School with dice code 18010519102 was amalgamated with the Reena Dabri High School with dice code 1801057 Paradiga as the base school. Though in the said order of amalgamation dated 09/08/2017 of the state government in the secondary education, amalgamated under 6 Khetra scheme, the petitioner was shown as the in-charge headmaster of said was shown as although shown as a such and such in a very high school, and his name was reflected at serial number 3 in the AW High School, whereas that of the respondent number 5 at the authorities in the BTC on 03/11/2018 issued a notice informing all concerned about the selection for the post of headmaster, headmistress, superintendent, etc. in the provincialized schools and provincialized high madrasa under the BTC area, following the provision of Rule 14 of the Assam Secondary Education within bracket Provincialized Service Rules 2003. Specifying that, clarifying that 17/12/2018 shall be the last date of duly filled up application by the intending candidates. In the said notice, for the post of headmaster, such provincialized high headmaster, headmistress, superintendent, high school, public high madrasas under the BTC. The prescribed educational qualification was page 16 or C. Under clause C was listed. In the said notice dated such and such, the teaching experience at clause D, for the post of headmaster, headmistress, superintendent was specified as minimum 10 years as graduate teacher. On 12/11/2018, the authorities in the school education of the BTC notified that the post of headmaster, headmistress, superintendent of provincialized high school of high madrasas shall be taken for the consideration up to the vacancy for the vacancies up to 31/12/2019. By notice dated 08/02/2019, the Director of Education BTC notified that for selection to the promotion to the post of headmaster in provincialized high schools, public high madrasas, this Kokrajhar district in under the BTC shall be here on 20/02/2019 from 10 a.m. onwards in the office of the Director of Education BTC. Both the petitioner as well as respondent number 5 appeared before the concerned selection committee for their promotion to the post of headmaster of Reynadabari, RAINADABRI High School. The Director of Education BTC Kokrajhar by order number BE/BTC capital APPT -219 PT -1 2018/22 dated 05/03/2019 on the recommendation of the Council Level Selection Board BTC and on the approval of the Additional Principal Secretary BTC dated 04/03/2019 appointed the respondent number 5 assistant teacher of Reynadabari High School, the Kokrajhar district, as a regular headmaster of the said high school. The pay scale of rupees 22,000 dash rupees 87,000 with grade pay of rupees 11,500. The pay band 3 plus other allowances as admissible under the rules with effect from the date of joining at such and such high school in the post that fell vacant due to superannuation of Sarbananda Burman, retired headmaster of the said school, suspending earlier orders if issued from the said office, placing in charge headmaster. Being aggrieved, the petitioner has filed this petition on 07/08/2019, submitting that the respondent authorities in the BTC, disregarding his seniority and eligibility, promoted the respondent number 5 to the post of headmaster in the said such and such high school. It is also submitted by the petitioner that the respondent number 5 service The service of the respondent number 5 was a teacher of the ME school, was amalgamated with India High School, wherein he is the in charge headmaster. The responding authorities in the BTC have filed an affidavit. This matter. And submitted that in the manual dated 25/02/2019 of the council level selection board for promotion to the post of headmaster, headmistress, and superintendent in provincialized high and high madrasas under the BTC. The concerned board, after considering the case of the petitioner as well as that of the respondent number 5, found that the respondent number 5 was appointed as a graduate science teacher in November 1991. And since then, the said respondent number 5 received the graduate scale of pay. But in the case of the petitioner, he received graduate scale of pay only from the date of provincialization of his service under the provisions of the said 2011 Act as amended with effect from 01/01/2013. Therefore, the concerned board came to the conclusion on 25/02/2019 came to the conclusion that the respondent number 5 is senior to the petitioner as he received graduate scale of pay since November 1990. And accordingly, decided to promote the said respondent number 5. The notice issued by the respondent BTC authorities on 3/11/2018 notifying all the intending and eligible teachers to submit their applications as per the proforma annexed the said notice along with all necessary testimonials in support of their qualification in the office of the inspector of schools of the concerned district. Both the petitioner as well as the respondent number 5 have the requisite academic eligibility, that is graduation with B.Ed degree from the NCT recognized institutions. As noted above, that the said notice of the respondent BTC issued on 3/11/2018 clarified that such promotion to the post of headmaster, headmistress, public superintendent in provincialized high madrasas shall be in terms of Rule 14 of the Assam Secondary Education within the Provincialized Service Rules 2003. Moreover, the said notice dated such and such also specified that minimum 10 years as a graduate teacher for the post of headmaster, headmistress, and superintendent. In the case in hand, the service of the petitioner was provincialized with effect by order dated 21/08/2013 issued by the Director of Secondary Education Assam with effect from 01/01/2013 under the provisions of say 2011 Act as amended during its course. And since then, the petitioner received his graduate scale of pay. However, he did not fulfill the requisite criteria of 10 years as graduate teacher for the post of headmaster in said NW High School. Till 17/12/2018, the last date of filing such application in terms of the said notice dated 3/11/2018. As such, the petitioner at the time of consideration of his case for the post of headmaster in such and such high school lacked the said requisite eligibility of 10 years of service as a graduate teacher for the post of headmaster. Since the petitioner lacks the eligibility criteria to that extent, he cannot claim for his promotion to the post of headmaster, regular headmaster in such and such. Order. This petition being devoid of merit stands.
May it please your lordships. My lord, the matter was listed on I-123 lordships. Standing Council of Education Department was directed to submit the status report, lordships. Lordship, this petitioner is the assistant teacher, lordships. Her service was provincialized in 2013, lordships. And since then till date, she has not been paid her salary, lordships. Lordships, already the Honorable Court was pleased to pass an order on 21/10/2019, lordships. And at that time, lordships, the Honorable Court directed regarding current salary if she is working to be paid, lordships. But as on today, neither the current salary nor the arrears have been paid, lordships. Page 20, lordships. Order dated 17/8/2013. Lordships, my name is Bontibala Nath, lordships. Serial number 4, lordships. And lordships, an order was passed on 26/2015, page 35. Passed by the Director of Secondary Education. That is the last paragraph, lordships. Srimati Bontibala Nath is entitled to receive salary on the strength of provincialization order dated 17/8/2013 and approval of the Finance Department accorded by letter number 1/2/2014, page 35.
এম খাটনিয়াৰে হেণ্ডল কৰি আছিল নেকি? এম খাটনিয়াৰে হেণ্ডল কৰি আছিল নেকি মেটাৰটো? তেখেতে চাইছিল ন? Yes, sir.
Lordships, I have made him party lordships. Notice was served. As on now, no affidavit is filed by him lordships. He is respondent number 6 lordships.
Use on.
Yes.
Please, Your Lordship. Lordship will kindly come to page 101, Your Lordship. That's the impugned order that we're challenging in the writ petition. Yes. Yes. 75 petitioners. They were initially engaged as part of the non-formal education scheme, Your Lordship. Their services were terminated in 2001. Thereafter, a series of litigations continued, pursuant to which there were directions from His Honorable Court, Your Lordship. Yeah. To file our affidavit. Era 7, the affidavit. Mary. With regard to the statement made in para 19 of the repetition, the answering respondent begs to state that in compliance of the Honorable High Court's order dated 25/7/2007, passed in WPC number 2694/2011, and as per the instruction of the government by letter number so and so dated 12/1/2011 and letter number so and so dated 9/6/2011, the Director of Elementary Education Assam submitted a SIU proposal for absorption adjustment of the service of the erstwhile non-formal education supervisor, showing the vacancy position of lower primary school teachers, by letter dated 3/3/2011 and 15/6/2011. Thereafter, the petitioner again approached this honorable court by instituting WPC 243/2015, and this honorable court, by the order dated 12/7/2018, directed the Elementary Education Department to place the report regarding relaxation of the Right of Children to Free and Compulsory Education Act 2009 and NCT guidelines for specific qualification before this honorable court. Thereafter, this honorable court again directed the state in the Elementary Education Department and Finance to submit decision after joint sitting about the absorption of the petitioners as elementary school teachers in terms of order dated 25/7/2007. In compliance of this honorable court, order dated 12/7/2018 passed in WPC number 243 of 2015, order dated 25/7/2007 passed in WPC number so and so, and order dated 21/5/2019 passed in WPC number 243 of 2015. The Government of Assam in the Education Department issued order dated 19/7/2019, rejecting the claim of the petitioner in terms of the judgment and order dated 25/7/2007. The claim of the petitioner for absorption in elementary school was rejected, since the petitioner do not possess the required qualification to be appointed as assistant teacher in LP school, as prescribed in the Right of Children to Free and Compulsory Education 2009 and in the notification guideline issued by the NCT. The NCT has issued a number of notification guidelines from time to time regarding the minimum qualification for a person to be appointed for appointment as a teacher at the elementary level. Besides the educational qualification, the other professional qualification as prescribed by the NCT, passing of TET is mandatory for appointment of teachers subsequent to the enactment of RT Act. Since the petitioner do not possess the qualification as prescribed by the NCT and RT Act, the case of the petitioner for absorption as assistant teacher in elementary school could not be considered, and hence their claims were rejected. If your lordship will find the orders of the court, of this honorable court earlier, page 44. What was the direction, my lord? At page 46. We were asked to consider the case and examine whether we can absorb them as per any government policy or not. But the challenge made in all those repetition was with regard to their termination. And the honorable court did not help that the termination was illegal. And their terminations were given effect from 15 March 2001. Which you will find page 47, the first repetition which was filed by the petitioners. May I read page 48? Heard Mr. So and so, by this repetition, a prayer has been made challenging the operation of the impugn order dated 15/3/2001, that is the termination order, whereby the petitioner serving as supervisor under different projects of the normal formal education, which came to an end on 31/3/2001 as per terms and condition of the agreement in reference to thereto. The said termination order 15/3/2001 has been passed. It appears that the projects were centrally sponsored scheme under the control of district officer in charge, assistant registrar, non-formal education. According to the petitioner, the court was pleased to stay the operation of the impugn order, and by virtue of the interim order, they have been allowed to work. And according to the learned counsel for the petitioner, large number of supervisors could be regularized, absorbed. it has been submitted or on behalf of the petitioner that the court on 4/4/2005 in a similar case directed the respondent, particularly the Director of Education, to consider the cases of the writ petitioners by the Director of Elementary Education. In view of the above, the petition is disposed of in terms of the order dated 4/4/2005 as indicated above, and the respondents are not in a position to controvert the prayer made by the learned counsel for the petitioner. However, for the interest of justice, the writ petition is being disposed by directing the respondent, particularly the Director of Elementary Education, who shall examine and consider the case of the petitioner sympathetically for adjustment, regularization, absorption, or in terms of the relevant government policy in accordance with law if the petitioners are found entitled. Now, this post of assistant teacher, these are direct recruitment posts, and we are bound to follow the prescription of law, which has been given by the RTE and the NCT. We have no power to relax that prescriptions. And in the earlier round of litigation, also page 57, the affidavit of the government, which they have annexed. Categorical stand has been taken that there is no policy decision of the government for adjustment of the employees of the erstwhile non-formal education scheme against regular posts under the education department. Ballot from page 57. Lordship will take page 59, para 5. Out of the above-mentioned categories of incumbents, the following numbers have since been adjusted against regular equivalent posts in different directorates. Categories are district officers, project officers, senior consultant, consultants, UD assistant, LD assistant, grade 4. The aforesaid adjustment regularization mostly were made by the government in pursuance of the order passed by this honorable court in some writ petition. However, to the information of the deponent, there was no policy decision of the government for adjustment of employees of the erstwhile formal education against the regular posts under the education department. Regarding supervisor, the deponent further states that with a view to adjusting supervisor of non-formal education against the post of LP and upper primary school teachers, the government had allowed them to appear before the special selection committee. This was done in the month of February and March 2006 after announcing in the newspapers. It may be mentioned that out of 560 persons who appeared, 197 were found to be eligible, including reserved categories. The required educational qualification was HS pass with at least second division. The recommendation of the selection committee have since been sent to the government by the Director of Elementary Education. Regarding instructor and instructees, as the instructor and instructees, the deponent begs to state that they were engaged purely on ad hoc basis at a fixed remuneration per month. Not applicable. So, to claim up absorption, they don't have any right. In this repetition, they have challenged the speaking order. In my humble submission, there is nothing wrong in the speaking order. The claim of the petitioners could not be accepted because they don't possess any qualification.
Yes. 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 Yes, yes, a contractual. It's a contractual scheme, yes. Yes, absolutely. Your Lordship. Yes, absolutely not. Absolutely not. Not. Yes. Yes. Along with qualifications also. Yes, 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 yes. Yes. The act came into force in 2009. The rules came in 2011. Yes. Yes, yes. Yes. Yes.
Well, cannot, but the scope of 2017 X is confined to the persons who are working in a venture educational institution.
If I may be permitted to take your lordship to two pages, yes.
Is number 81. It is a communication to the senior standing council with regard to the vacancy. Madam. You will find the last paragraph. 2694/2001. 2694/2001, Your Lordship, the order is at page 69. Yes, yes.
Well, well, depend.
Yes.
Page 100, Your Lordship's order, madam. Yes. We were given an opportunity to discuss with the finance department in a joint sitting to take a decision, and that decision, my lord, culminated in 14 June 2019, my lord. Though as per the orders passed earlier to consider their case, a initiative was taken, my lord. And nowhere, my lord, this honorable court held that they have a right to be absorbed, my lord. Yes.
But the government followed through with the directive which was given by this honorable court. Rights had accrued, Your Lordship, and prior to the NCT Act.
No.
This honorable court had clarified, Your Lordship, but there was a selection committee set up to find out the vacancies, which resulted in 197 vacancies, which were documented by the government, Your Lordship, in correspondences. The petitioners were highlighted. Yes. Yes. Correct. Yes.
Yes, but that determination, your lordship, they came belatedly to cover up their inactivity. Your lordship, the rights of the government had the rights have not accrued. I cannot submit to that. But your lordship, yes, yes. There was a ban on appointment, then the appointment was lifted. The ban, yes, your lordship. The ban was lordship was lifted in 2012. The act came into place in 2009. The rules came into place in 2011. The letter, your lordship, at page 81, that your lordship had so rightly highlighted, and the letter at page 80, both the letters, they state that the government had taken steps to identify vacancies and to categorically absorb the instructors and instructress that the petitioners fall into, your lordship. The 195 retrenched supervisors, page 80. The government had directed, subject to what your lordship deems fit, that the government had directed that the appointment of the stated petitioners in the mentioned list to kindly be allowed by taking leave of this honorable court. Page 80 and page 81, your lordship would see they have come and they followed up with the direction which was given by this honorable court. The honorable court did not direct the petitioners to be absorbed, as the lordship had correctly pointed out. That is not my submission. My submission is that the government followed it up. The government identified. The government took steps. Thereafter, in the year 2019, they say that the RTE Act had come into place. The RTE Act had come into place. I cannot subject against it. You cannot submit against it, your lordship. But my cause of action had arisen at the prior point in time. The honorable court had directed the government to take steps, and the government took steps, your lordship. In fact, if your lordship comes to page 69, the entire direction that was given by this honorable court to the government was directed to be completed within 3 months. The government pulled along the petitioners along the way for 15, 20 long years, your lordship. Thereafter, they say, which is a right submission, that we do not have the qualifications, but that could have been made apparent at an earlier point in time. That was never made apparent, your lordship. Our qualifications were never brought into the picture. Okay. Oh, that's right.
Hello. 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 Yes. Hello. Yes. Hello. Secretary. Petition.
7666.
PTCQ. 6. বহুত আছে কোৱেশ্চন কি লৈছে
if I may submit one point, Your Lordship, respond number 6 is BTC, Your Lordship. Yes, respond number 6.
In this record has not been received yet, my lord. So my lord, some time is required, my lord. Record director and my lord, and I was directed to produce the record from director and the district. And the district, my lord. Yes, my lord. Well, I have.
But otherwise, my lord, on 28 to I have retired, my lord.
On 6 of 11. JM Sulaiman. JM Sulaiman. JM Sulaiman. Respondent 6.
On Friday.
It is your worship. This gentleman has retired time back. It's regarding fixation of fee, and also now pension has also been fixed at a lower rate. My lord, the affidavit has not been filed till today. In the meantime, my lord, two directors retired. One director filed an affidavit saying that the college did not send the papers. Then he was transferred to some other post. But the college principal has filed an affidavit saying that we have already given all the papers for correction. And it is hanging, my lord, since 2015.
Mr. Sharma, get hold of Mr. K. Gogoi. If he is busy, then get hold of Mr. Tahvildar, whoever is there.
Now, lastly, my lord, the respondent number 5 has been implemented the present director of higher education.
Let us see. Mr. Das. The judgment of 80, yes, want to say something?
In item 15, my lord, as per the instruction received, the department has asked the college authority to provide the documents, my lord.
That is the thing. The college authority has filed an affidavit that it was already given to the director of higher education.
That was in 2016, 2017, my lord. 26/4/2017, the FC principal has said we have sent all the papers.
Mr. Do one thing.
Yes, madam.
Give the copy of the affidavit and of the college authority and the copy of the judgment to Mr. Das today itself. Right? And we will have it sometimes on 24th after that status.
Yes, yes, sir.
देखा मैं जिला पेंसिल पेज नंबर 2 रूट करा Sharma book market Mr. M.K. Sudhir, Senior Counsel. Assisted by Mr. Absorption, Counsel appearing for the petition. Also heard Mr. S. Das, Standing Counsel Higher Education. Petitioner, a retired professor in the Department of Statistics, Dudnoi College, a provincialized college of the state, preferred the connected WPC, converted the WPC number, preverted it, petition WPC number 3545 of 2015. For rectification of the date of effect of the selection grade scale payable to him from 10/07/1995 to 01/01/1996. The
court, after hearing the parties and considering the matter by order dated 18/06/2015, disposed of said application number 3545 of 2015 with the following direction. That is already by page number 10 of the slide. This placed before the court that till date, the respondent authorities in the higher education department have not paid him, given the benefit of selection grade scale of pay of rupees 12,000 to 18,300 and payment to Military during the period from 10/7/1995 to 01/01/1996. In accordance with the UGC scale, though he is entitled for the same. Accordingly, the principal of Dudhnoi College as well as the director of higher education Assam on the next date fixed shall apprise the court about the up-to-date status of compliance of the said order dated 18/06/2015, passed in WPC number 3545/2015. Since Dudhnoi College is a provincialized college as noted above, the Director of Higher Education Assam, in exercising his power as the director, shall collect all the relevant information from the college authority. Noted above. Based on 24th of March.
My friend is, I think, appearing for.
I am for respondent number 2, my lord.
Give whatever is required. What's your good name?
T. Nath, my lord, on behalf of B. Pathak.
He is the principal of the Dudhnoi College. He is not on behalf of the principal of the college. Mr. Bokututi, Mr. Bokututi, you can furnish the copy of the orders to both the officers. No representation on behalf of the parties on call. Do name of 3 counsels for the petitioner. Petitioner speaker. And 12 counsels for the respondents have been reflected because list. Contempt petition still dismissed for non-prosecution. Notice of contempt. 0308-2016. Was hereby referred this contempt petition is against non-compliance of the order. Common non-compliant common order dated 17/07/2014, passed in WPC number 3284/2007 and connected matters.
Non-compliance of order dated 21/3/2016. Earlier, my lord, instruction was not called for from respondent number 2.
Call anyone standing in call BTC. You will take it after some time. Inform any standing council BTC. Inform any standing council BTC.
We have received instructions that the pension has been released in 2022 itself, my lord, by the order dated 9/3/2022, the pension was released. Sorry, my lord, it was the area salary.
No representation on behalf of the petitioner on call. The name of 4 councils have been reflected in the cause list. During the deliberation of the matter, Mr. R. Mazumdar, Standing Council, Department of School Education. Yes. Copy of the order dated 20, copy of the communication dated 21/02/2023 of the Director of Secondary Education, Assam. Matter pertains to full disobedience and non-compliance of the order dated 11/11/2016, passed in WPC number 282/2016.
whereby the Director of Secondary Education Assam was directed to look into the grievances of the petitioner and thereafter to reduce her due salary as a craft teacher of F. Ali Ahmed High Madrasa from the date of her initial joining till 28/02/2014. Joining letter. Date of her initial joining 18/12/1983. On 2016. Communication. But the said communication dated 21/02/2023. The Director of BSc Assam placed before the court that in respect of the petitioner Gul Bahar Begum, craft teacher of F. Ali Ahmed High Madrasa, District Nalbari, an amount of rupees 14,99,110 had already been sanctioned by the state government on 7/03/2022. And thereafter, the budget allotment for the said amount was released against the drawing and disbursing officer of said F. Ali Ahmed High Madrasa by the allotment dated 09/03/2022. In that regard, the DSC Assam has also placed a copy of the communication dated 07/03/2022 of the Commissioner, Special Commissioner Secondary Education about sanctioning of said rupees 14,99,110 in favor of the petitioner towards our year salary. Since the respondent authorities have already complied with the order 11/11/2016 passed in WPC number 282/2016, there is no such contempt on the part of the respondent authorities. According to this contempt and dismissed. The notice of complaint is earlier on 09/06/2017 on the respondent's certified copy of the communication dated 21/02/2023 of the UPSC Assembly before the court will be kept as a part of the record. Adesh.
Oh, he has come with.
See, give him a copy of that order.
My lord.
And,
It would.
it's not a very complex issue. You're supposed to, the PTC authorities is required to forward the names to the court-appointed committee. And they will look into it and then they'll pass the necessary order. And that was the direction given on 21st of March 2016 in WPC number 1953/2016. So it is the BTC authorities who is required to forward it at the earliest, but nothing has been done till now. That's why this contempt petition. Mr. President, Secretary, Council appearing for the petition. And Mr. Standing Council BTC.
On the next bit fixed. The the Director of Education BTC shall apprise the court about the compliance of the order dated 2103-2016 passed in WPC number 1953-2016 placed on 29th of March. Keeping the name of litigant counsel petition in the court list under the respondent column. Give him a copy. And the copy of that order of the no representation on behalf of the petitioner shall call. Matter person pertains to non-compliance of the order dated 24/11/2016 passed in WPC number 3411/2016. Though the cause list reflects the name of two counsels, none appeared in the matter. Petitioner may not be interested to pursue this contempt petition. Stands dismissed. Notice of contempt issued earlier. Notice of contempt to the respondents earlier on 02/08/2017. Is hereby recalled.
Lordship, petitioner is a retired person, Lordship. Petitioner has now retired, so petitioner want to withdraw this case, Lordship.
Are you sure?
Yes, Lordship. Petitioner directed, Lordship.
Which petitioner? All the petitioners.
All the petitioner, Lordship.
What's your good name?
Jay Kolita.
Third MS Jay Kolita, counsel appearing for the petitioners. On instruction, the petitioners, Ms. Kolita is not pressing this contempt petition. Accordingly, this contempt petition filed against the non-compliance of the order dated 31/05/2016 passed in WPC number 5185 public 2014 stands liquidated. Dismissed. The notice of contempt is upon the respondent authorities earlier on 24/11/2017 is thereby recalled.
Our case has been repeated. Sorry, concern.
Matter 42. Non-compliance of the order.
22.
No, not so.
Read petition?
It's a read petition.
Madam. Madam, here, madam, we had evaluated her, the position of the petitioner's husband. She has filed it, and she claimed that her husband was serving under the education department. When all the Dhamaji and Lakhimpur matters were looked into, although many were accommodated on finding some basis of their claims, petitioner's husband, madam, we could not accommodate.
Do you have any?
But only the short written instruction is here, exactly why he was not recommended, madam, that I have to bring up. Otherwise, madam, the list. I'm just sharing the information that we have received now. Code 3, code 3. আছে না? হ্যাঁ, নেটওয়ার্কে প্রবলেম আছে না?
No, kindly see that particular against her name.
Yes.
Then offered appointment, not approved by the government for accommodation.
Not approved. That is what I was showing with WPC. Offered appointment not approved. Not approved, while Lordship will kindly have page 42 for a moment of the petition. The middle paragraph, therefore, in view of the above, the authorities will examine the case of each and every petitioner, whether they had been served so post notice for termination of the termination orders And if it is found that no so cause notice or termination order has been served to them, they will be entitled to get salary for the service rendered by them as given to them for the period from so and so to so and so. Lordship will find at page 36 where the order starts. Serial number 8 is the teacher, is the husband of the petitioner. Now, if Lordship has the next page, page 40. It is the observations of the
Page
43. Observation. It is observed from the aforesaid report of D.O. Hemaji that so cause notice were issued to the petitioners during March 1992 before termination, and they had submitted their replies during April 1992. The replies submitted by the petitioners were not satisfactory and they were appointed illegally against non-existing posts. As the so cause notices were issued, the petitioners and replies of the so cause notices were not satisfactory, and as such the petitioners were terminated from services during the month of 1992 after giving them 29 months salary admissible to them. Further due procedure as per some discipline appeal rules was maintained by giving show cause notices before termination of the petitions, as such petitioners are not entitled to get their services.
When this exercise was done?
This was in 2015, my lord. And finally the accommodations, they had come up in the year 2021, if I'm not wrong. One aspect, my lord, may like to have a look. The judgment given by the petitioner at page 44 onwards, there, my lord, the Supreme Court had held that if the order of termination was not supplied, and here, my lord, in this order, I do not find that sentence saying that the order was in fact served upon him. That perhaps will come up in the report. Even thereafter, at page 49, we would still then call them for a hearing.
They appear or not?
The petitioner's wife was referring to that.
It was in the name of husband of the petitioner.
Yes, because the husband of the petitioner was the person who was allegedly in service.
That was in 2016. He was probably not in service. He's already not existing in the world. When did he die?
He died in harness in, they say paragraph 15 on 2/7/2014.
So,
but petitioner paragraph 16 says that she had appeared on his behalf. Whether she could continue with the quest of her husband. That will be another aspect of it.
representation on behalf of the petitioners on call. Lord Mr. R. Mazumdar, Standing Council, Department of School Education. Petitioners on call. The name of two councils have been reflected in the first district. Lord Mr. Ramon, Department of School Education. Mr. Submitted that pursuant to the order of the court dated, where is that order of justice?
Page 43, madam. Only one aspect on the page 39.
Order of the court
Advocates who had
dated
appeared
27/04/2012. Passed in WPC number 5635/2007. The husband of the petitioner was petitioner number 8. The authorities concerned in the elementary education took certain steps for
compliance of the order dated 02/03/2021, passed in WPC number 8478/2019. And with regard to the petitioner's case, WPC number 1716/2017, i.e. the present case, our case was forwarded for appointment, but her case was not considered by not approved by the government for accommodation. After considering all the relevant materials on record, the respondents in the elementary education department may place the same fact by way of an affidavit. Such affidavit shall be filed by the respondent in the elementary department on or before 17th of March, based on 21st March. Mr. Majumdar?
My lord, yes, we'll file an affidavit. My lord, in item number 23, we have preferred a writ appeal, my lord, where notices has been issued.
And this is already state lordship. The order in the writ appeal, it is already stated by the apex court lordship.
Writ appeal to disposition.
Stay for research. Writ appeal or very good.
Notice went to the SLP.
SLP for research.
Who against notice?
Notice one is the delay to non-police. In a lordship writ appeal, the delay was condoned 2000 something days were delayed lordship, and it was condoned. And against this lordship, the petitioners approached, and it is state lordship. Otherwise, in the contempt petition, there was a direction to comply the order. There was a direction to provincialize the petitioner service.
Okay, during the deliberation of the matter, it is submitted that against the order dated 25/05/2016, passed in WPC number 4644/2014, a writ appeal was filed by the state respondents.
Writ appeal number 387 of 2020.
WPC writ appeal number 387
of 2022.
With condonation petition. The Honorable Division Bench, after condoning the delay, it should notice to the respondents of the great petitioners in said writ appeal. Ms. RDB counsel appearing for the petitioner submitted. Presently, the matter is pending in an SLP before the Honorable Supreme Court, as some of the petitioners have challenged the order condoning the delay by the Honorable Division Bench in said writ appeal number such as list after the disposal of the matter by the Honorable Apex Court. The petitioner, after such order of the Honorable Division Bench, may make a mention of listing this matter.
Right.
It's a review by the state of Assam, my lord. She would find the order of which we seek review at page 20, my lord. Starts at page 22, 21, my lord.
Notice have been issued. They have appeared.
Perhaps not. Yes, Mr. R.M. Dekka and Mr. M. Das appear for the respondents. Given that I have just given the latest instruction we have received after filing of the review petition. The petitioner has been accommodated as a tutor, my lord, and she has also given up her past claims and she is now drawing her salaries from 3/6/2021 onwards.
Hard Mr. R. Mazumdar, Standing Council Elementary Education. Sorry, Standing Council Department of School Education.
No.
For the respondent authorities. This review petition by the respondent authorities, sorry, by the authorities in the department, elementary education have filed against the order dated 02/06/2016, passed in WPC number 4876/2010. Notice was issued upon the petition respondent / petitioner. Sole respondent of the petition. On 27/04/2018, the sole respondent is represented by its by her two counsels, whose names have been reflected in the deposits, but the said respondent will not be presented on call. During the deliberation of the matter, Mr. Mazumdar appeared on behalf of the authorities in the elementary education department of the state, submitted that after approval of the finance department, the director of elementary education Assam by an communication dated 03/06/2021 allowed the petitioner, so appointed the petitioner as a
tutor.
Tutor. In Rangpuria Lower Primary School in the Bordoloni Education Block of District Dhemaji, and she joined school after accommodation on 01/02/2021, for which
21st of March.
Appointment orders were issued to her on 30/01/2021. Mr. Mazumdar on instruction also submitted that the full respondent is receiving her fixed pay as tutor since 03/06
03/06.
The review petitioners may shall, by way of an affidavit, shall place the said facts before the court within a period of 2 weeks from today. Some date to be fixed by the registry. God bless you.
Non-compliance of the order dated lordship 9 to 17, page 19. The petitioner were originally appointed on a regular post but on consolidated pay after due selection. Thereafter, lordship petitioner was not given consolidated pay for a long period. And this court has directed to pay regular scale as well as now regular scale has been paid, lordship, area has not been paid.
নহয় সেইটো আপোনাৰ ফাইনেন্সৰ মই ফোনটো জিডিঙৰ কথা কৈছোঁ চন্দ্ৰশেখৰ কিনো চন্দ্ৰশেখৰ কিনো মিডল নেগোচিয়েশ্যন উইথ ইন্সপেক্টৰছ
হেড কৰিব লাগে
কৰিবতো ভাল কিন্তু এতিয়া চন্দ্ৰশেখৰটো আমাৰ কোন আছে
সেক্ৰেটাৰী
নাই শংকৰ সিঙৰ সেক্ৰেটাৰী আছে
Samsung আছে নাই
সাবসিডিশন নাই Matter pertains to non-compliance of the order dated 09/02/2017, passed in WPC number 6569/2015. Mr. Majumdar, whether your colleagues are not aware about the judgment rendered by the Honorable Apex Court in the case of fence sitter?
Yeah, well,
you may be aware, I don't know about your colleagues.
well, they put up that we put up the defense in several cases.
It's not there. No mention about that. There was a writ petition of 2013, disposed of sometimes in 2015, 2016, and 2015, I think so.
pending আছে তো pending আছে তো কমপ্লাই কৰা
এইটো it was a writ petition 5499/2001, wherein order was of 26/9/2003. Chalo, non-compliance with the requisition. It is submitted by Mr. Goswami, counsel for the petitioners. The petitioners that the petitioners hearing are receiving their regular salary, but they are yet to be paid to pay their arrears salaries. Placed on 31st of March, enabling the respondent authorities in the secondary education to apprise the court about the status of compliance of the order dated 09/02/2017. First in W2C 6569. Tell us.
Nice.
Timing item number 3.
Next one.
47.
There's a review petition, your lordship has earlier issued notice, your lordship. On the ground, your lordship. An order has been passed by this honorable court, that is at page 71, your lordship.
Lordship, may I submit one thing, Lordship? Today only I have received a copy of the review petition, Lordship. So I may be allowed some time to take instruction.
You're appearing on whose behalf?
I'm appealing to the respondent 1 and to the read petition.
Ultimately, my prayer will be, your lordship, to send the matter back to the court where the revision petition is pending.
Heard, Mr. as whatever counsel appearing for the review petitions, and Mr. D. Das, grant counsel for the respondent numbers 1 and 2. I think so.
1 and 2.
Mr. Das submitted that he has received the review, copy of the review petition today on pair of Mr. D. Das, placed this matter on 16th of March. Just a minute, just a minute.
16th.
Lordship. 15th of March, 15.
16th is a hearing day.
So 15th of March.
Lordship. Deeply over.
May it please the lordships. Petitioner before lordships, all are a Hindi teacher, my lord, appointed before provincialization, and by the managing committee, my lord. And they challenge in the year of 2018, my lord, whereby the my lord impugned letter dated 6/2018, my lord, issued by the Deputy Director Elementary Education, whereby my lord petitioner have been deprived from the getting their service of provincialization. In respondent authority is by law honorable court permit page 41. This is the letter issued by the district element to the by the Deputy Director Elementary Education Assam to the Director Elementary Education Officer, my lord, regarding submission of proposal as per new Provincialization Act 2017, my lord. With reference to the subject cited above, I am directed to request you kindly resubmit the proposal provincialized services as per Assam Education Provincial Service Teacher Organized Institution Act 2070, page, my lord, 43, my lord. There is no room in respect of provisions for an additional teacher, my lord. There is no provision, my lord, there is no room, my lord, for us, my lord, as a additional teacher. My lord, if honorable court permit me, my whole submission was recorded by the honorable court on 11/4/2018, my lord. Your lordship, the last order, my lord. 11/4/2018, if honorable court permit me, whole submission was recorded, my lord. 11/4/2018, my honorable court, my lord, just a minute. Well, your lordship, go through the order. Well, I am going to read it, my lord.
Just
First order, my lord, 11/4/2000.
it's before us.
My lord. May I read, my lord? Petitioners are upper primary.
We have read it.
My lord, there is a provision, my lord. My lord, if honorable could permit me. Rule 3, eligibility criteria for selection of educational institution for provincialization of service of teacher tutor, my lord. 3, my lord. 8, my lord.
Just a minute.
Page 11, my lord.
Just I'm looking for an order.
2 number of teachers and tutors of Hansard LP school shall be provincialized under this act, and their service shall be marked. Sorry. Page 100. In case of Hansard upper primary school, there shall be minimum 3 teacher or tutor, at least 1 teacher each, or science, mathematics, social studies, and languages, not language, languages, provided that for additional posts, it shall be considered in accordance with the norms and standards stipulated in the schedule under section 19 and 25 of Right to Children to Free and Compulsory Education Act 2009. Now, my lord, what is, my lord, section 19 and 25 of the Right of Children to Free and Compulsory Education Act 2009? If there is a student more than 35, then they have to come in another 1 additional teacher, my lord. This is, my lord, if honorable could permit me, my lord. Children Free Compulsory Education Act 2009, my lord. Schedule, my lord. If honorable could permit me, honorable could, I am going to give, my lord. Or 6 class to 8 class, at least 1 teacher per class, so that there shall be at least 1 teacher each for science and mathematics, social studies, languages. Number 2, this is the important, my lord. At least 1 teacher for every 35 children, my lord. My lord, in this, my lord, the director letter, my lord, this column, my lord, there is no room for us, my lord. So thereby we deprive. As a Hindi teacher, we are a Hindi teacher, but they did not do it. Our school is concerned, all are more than 35, but they did not call. There is no any room in the particular format. So thereby, all Hindi teachers are deprived for their legitimate rights, my lord. So rules specifically mention that C is concerns languages, not language, and provided that for additional posts, we are concerned in additional posts in that particular format, my lord, which I challenged before your lordship in 2018, my lord. So honorable court, is all submission recorded. They given an interim, my lord. Pendency of this case shall not be operated as a bar for the respondent to invite proposal names of additional Hindi teacher in terms of provisions of this act, but they did not do it. So well, at least their affidavit is required, my lord. They did not file affidavit from 2018 onwards, my lord. So in the format, my lord, by format issued by the director, my lord, page 43, envisaged only two categories: recommended teacher, tutor, and non-recommended. My lord, but regarding it, additional teacher, those who are in student more than 35, that, my lord, condition that did not, my lord, given any room. So thereby, my lord, this inviting the proposal, it, my lord, patently the fallacious, my lord. In as much as, my lord, the same do not provide room for recommending the additional teacher as per, my lord, section, my lord, 3 of this act, my lord, as well as section 19 and 25, right of children of free and compulsory education act 2009, my lord. So, my lord, my fear is that, my lord, we are depriving. So at least those school, the children who are more than 35, they may be considered, my lord, as per procedural law. My lord. My lord, page 41, my lord. They only given the non-recommended teacher and recommended teacher. Only two categories, envisages only two categories. And my lord, if honorable permit me, paragraph 12, my lord, in my petition, my lord.
Yes, can you read?
It is stated that the enrollment ratio in respect of class 6 to 8 for the year 2014-15, 2015-16, 2016-17 in one school as recorded in DICE data as follows. Only I am going to given the one school is concerned, my lord.
Mr.
My lord,
Bora, how you are affected with this order?
because of that, our those students who are more than 35, they may be given additional teacher, my lord. That recommendation, this format of this issued by the director, there is no room, my lord. If on our page 43, my lord, they has to do as per law, my lord. Thereby we are depriving, my lord. At least they can inquiry, and after inquiry, they is going to show that there are 35, more than 35 as per law. They may be required for provincialization, my lord. But they do not do it. Language teacher only given one, but the rule says that languages in 3 languages are there.
See,
Yes, my lord. I am not on that in languages, but in respect of I am paying for additional teacher. Those who are in more than 35 teacher as per law, it clearly says, my lord. If schedule, my lord, if honorable court permit me, my lord, schedule of the act, the right to children to the free and compulsory education act, the act is clearly says that provided that for additional posts, it shall be considered in accordance with the norms and standard stipulated in the schedule under section 19 and 25, the right of children to free and compulsory education at 2009 Central Act. This 2008 schedule says, my lord, for 6 to 8, at least one teacher for every 35 children. 35 children, man, where admission children is above so and so, so and so. That means, my lord, if science and mathematics, social science and language and theater, my lord, one additional teacher may be given if more than 35 students are there in the school. But our school is concerned more than 35. Some school has 100, some 150. I am not going to that without inquiry. You may give us.
But Mr. Enbora, counsel appearing for the petition, and Mr. R. Malinda, Standing Counsel for Department of School Education. On 11/04/2018. So The observation that tendency of the case shall not operate as a bar for the respondents to initiate proposals, names of additional Hindi teachers in terms of the provisions of 2017 Act. Till date, the respondent authorities haven't filed any affidavit in the matter. Based on 10th of March and on the said date, the Director of Elementary Education Assam shall place the relevant records in original, in which the Deputy Director Elementary Education Assam issued the communication number EPD/46/2017/107 dated 06/02/2018. Just accordingly.
Lordship. As per office note, my lord, dated 17/2, my lord, services awaited upon respondent number 8, my lord. Lordship, it's a director of elementary education. Can it be served through the council, my lord?
That's not possible.
Then, my lord, I may be allowed to take fresh steps. My lord.
Mr. Mazumdar. What is the stand with regard to the excess teachers of Shivsagar, both in elementary and secondary?
My lord, the same accommodation which Lordship had gone through a little while ago, my lord, the same accommodation part had been applied to them also. They were also included in the entire.
No, that's
so
fine.
we'll have to find out whether the particular person had been recommended by the government to be accommodated or not.
But these orders will be.
Those teachers who were being accommodated, those teachers have given up all their past names while taking that appointment, because they had the choice of either taking the appointment and giving up the past claim, or they could have not taken that appointment and continued with their past claims. Those who have taken the accommodation, of them the claim goes, my lord.
Then it's very simple for you.
My lord, yes. So we'll have to find out what is the status of this person. That is what I placed in the Irani Gogoi case and also in the Taruni Fukan case, my lord. Here also I have to find out what is the status particularly. It was not in my opinion.
In one petition, there are 24 petitioners. Petition because a common order.
Yes, ma'am.
4 plus 33.
10 read petitioners, my lord, in this matter. My lord.
And the contempt case, there are 10.
Yes, ma'am.
Belongs to which WPC? First or second one?
Okay. 2710 of 70.
Get the information in that case.
What is?
The next is fixed. The respondent authorities in the elementary education department as well as the finance department of the state shall apprise the court about the compliance of the order dated 19/05/2017 passed in WPC number 2710/2017. Placed on 28th of March. Give me a copy of the order. You'll do the next. This shall reflect the name of Mr. R. Mazumdar in the cause list for the respondents. Matter pertains to non-compliance of the order dated 12/03/2018, passed in WPC number 5184/2017. Namely, the councils reflected in the public for the research, but no implementation on behalf of them. Stands dismissed. The notice of contempt issued upon the respondents. Result 03/09/2018 are hereby recalled.
28 is complied.
May I read your lordship?
What's your good name?
M. Hussain.
Not Mr. M. Singh. Counsel for the petitioner.
2022.
Mr. R. Mazumdar and Mr. S. Chaudhary for the respondent authorities. Matter pertains to non-compliance of the order dated 14/5/2018, passed in WPC number 2805/2017. During the deliberation of the matter, the Director of Eligibility Irrigation Assam, by its communication dated 30/05/2022, apprised the court that the petitioner that in compliance of the order that 14/05/2018 passed in WPC number 2805/2018,
2022.
an amount of rupees 4,21,118 had already been disbursed to the petitioner Ali Muddin Loskar, retired headmaster of Alambag BT MA School in the district of Kachar, which the petitioner had already drawn. In that regard, the concerned Block 11 Education Officer Salsapara, District Kachar, by communication dated 28/03/2022, informed the DEO Kachar that the said amount of rupees such and such had already been deposited in the SB account of the petitioner on 11/03/2022. As the respondent authorities have already complied with the order dated 14/05/2018, passed in WPC number 2805. This contempt petition being devoid of merit and dismissed. Notice of contempt issued the petitioner respondent authorities on 2/11/2018. Copy of the communication 30/05/20, part of the. Obliged, Lordship. None appears on behalf of the petitioner on call. Though name of the two counsels have been reflected in the cause list. Just a minute. And last appeal, the petitioner remain unrepresented. Non-procedural.
May it please your lordship. Already the matter pertains to for accommodated for the post of principal, but the petitioner is already retired from services. And the relief sought for is not raised.
Third M.A. Oja, Learned Counsel appearing for the petitioner, and Mr. R. Mazumdar, Standing Counsel, Department of School Education, for the respondent numbers 1 to 4. Matter pertains to claim of the post of principal in a provincialized higher secondary school of the state on the basis of on the strength of master degree obtained by him from Chhatrapati Shahuji Maharaj Kanpur University, Kalyanpur, and of compass mode. For the post of principal, Lahore Ghat Higher Secondary School. Ms. Soza, Learned Counsel appearing for the petitioner submitted that during pendency of this petition, the petitioner has already retired from service. On 30/04/2021. In view of the above, this petition stands closed.
Master place.
Petition, Lordship. Lordship, this matter will be closed as all the petitioner has got their relief, Lordship.
What's your good name?
D. Borua on behalf of Mr. Istas.
B.
D. Borua.
Matter pertains to non-compliance of the order dated 11/10/2018, passed in WPC number 6678/2018. On instruction of the petitioners, Mr. D. Burwa, learned counsel, appearing on behalf of Mr. H. Samiti, that during pendency of this contempt petition, the respondent authorities have already complied with the order dated 11/10/2018, passed in WPC number 667/2018. There is no such contempt of court the part of the respondent authorities for this contempt petition. In the word of arrest and dismiss the notice of contempt issued upon the respondents earlier on 27/0/2019 hereby recalled.
Where the instruction 19. Motion was putting more.
Given the total instructions already given.
Because
Through mail.
what is, let me swing you. Okay, metro was like. Monday, right?
So which did you have a sanction to go now?
My lord.
You have been already.
No, my lord, here only my submission, I may be allowed to give one submission. That was informed to petitioner. But now, before 1 hour, she has given me, there is some, again, some mistake is there. She has been informed. But anyhow, my lord, if this so, let me take instruction, because she has told me that it is not been fully complied. It is why I have to take instruction, my lord, let me fix after, and copy may be given to me. Copy of this letter may be also furnished to me so that I can place it. Morning today.
Heard Mr. Siburo, counsel appearing for the petition. And Mr. R. Mazumdar, standing counsel. Department of School Education. As well as Mr. Chakravarti, Land Council. You are appearing for whom?
Number one.
One. And you are for? Matter pertains to non-compliance of the order dated 13/06/2018. First in WPC number 614/2013. The court by order dated 13/06/2018 passed in WPC number 614/2013 that was preferred by the petitioner. Directed the respondent authorities in the Elementary Education Department to conduct an inquiry as to the period in which she worked in the school and thereafter to give payment of her arrear salary, if any. In that regard, the Director of Elementary Education, Assam, was directed to make a reason order with regard to the petitioner's entitlement for arrear salary by giving specific particulars and copy of the specific particulars. Pursuant to the same finding, the Department of School Education in the state government by communication number E-256567/122 dated 24/02/2023 informed the Accountant General in Assam about the sanctioning of rupees 1,25,004 for payment of arrear salary in respect of the petitioner, assistant teacher of Pub Guwahati Night High School, Kamrup Metro, for the period from 01/07/2005 to 21/07/2005 and 01/08/2005 to 28/02/2007. Said communication of the state government in the Elementary Education Department dated 24/02/2023 have been placed before the court by the Director by the Department of School Education through its communication dated. In view of the above, as the respondent authorities have already complied with the order dated 13/06/2018 passed in such and such 614/2013. No such content related. On notice of content such and such. Hereby recall notice of content issued on 27/05/2008. Copy of the communication dated 24/02/2023. Noted will be kept as a part of the record.
Order is page number 21, my lord. Relevant portion 23. Paragraph number 5, 6, 7, and 8.
Don't have a different kind of a sale for pension. Why make these people to run to the court?
The initial pension is, the provisional pension is initial.
But definitely it was the order passed by the court, right?
No, even in normal cases, the DO he disburses the initial provisional pension. then depending upon the status of the petitioner, it either comes from the directorate or from the pension. In fact, at page 23, madam, we have complied with para number 6, 7. I have given that instruction, madam. It has been sent to the director of pension from our end.
Yes, for the government
The director of pension,
All any government.
unfortunately, is not a party. Unfortunately, their pension is not a party here.
Not necessarily.
Otherwise, madam, we have done our part. The director has sent it to the DO has sent it to the pension department.
Mr. Sakya. Petitioner is a retired person. Lady. She is now 67 years old. 60. Her proposal re-estimated pension was forwarded to the director.
Lordship, may I make a submission, Lordship? Lordship, I have been informed by the treasury officer, who is also a party, that amount of 29,000 has been already put into the account of the petitioner. It has been dispersed.
Towards what?
The area salary, my lords. Area pension salary, my lords. That amounts to around 29,000, Lordship. If my learned friend is aware of that fact, my lords, sir.
I have not heard about this.
Lordship, if the petitioner.
Doesn't matter. Mr. Bozumdar, give him a copy of this communication.
After this communication, my lord, the
we'll get it. Once that amount is sanctioned, that is, we have nothing to do.
But that is what we saying. What we had sent to the pension department.
What was the
that has been
amount
released by the treasury officer, my lord.
Yes, Lord. 29.
Yes.
29,413.
That amount is not here exactly, only because the pension department had to do it. That if he says 29,000 has been paid.
Lordship, as per my instruction, the amount is
Because we had to pay the difference between the teacher's pension and the headmasters.
So in the meantime,
that would not be too much.
The meantime, the petitioner can also find out from the client, my lords, whether or not such an amount has been
pension for the city control police to
eligible. I have the bill details, Lordship. But the name of the petitioner is not there, but the token number and the identification number is there, my lord. So as per the instructions received, according to a treasury officer, the amount that amount has been given and it has been disbursed and it's in the account of the petitioner.
Just pass on that.
I can provide.
What amount you said? 29,000.
29,413.
From 13/3/2014 to 31/1/2015.
I can provide a copy of the bill details also. Lord. The token number. That is the bill detail, madam. That has been
Sending in contempt.
It says. Be sure.
29,413.
Education person? Education person? In fact, he also has a copy of the budget allocation for 29,413.
Heard Mr. Arali, counsel for the petitioner. Also heard Mr. R. Mazumdar, Standing Council, Department of School Education. Mr. A. Salihar, Standing Council, Finance.
Respondent number 4, Lordship.
The respondent authorities. Matter pertains to non-compliance of the orders dated order 19/6/2018, passing WPC number 3987/2018. During the deliberation of the matter, Mr. Salia, Standing Council Finance, placed before the court a communication dated 21/01/2022 of the state government in the Elementary Education Department, Assam, to the Accountant General AE for saying, intimating about sanctioning an amount of rupees 29,413 for payment of arrear salary in respect of the petitioner in charge headmaster of Absorption Milon ME School, District Nalbari. After resubmission of the pension proposal, on resubmission, after necessary fixation of pay as on 13/03/2014. Mr. Salihar, Learned Counsel, appearing for the Council Finance, on behalf of the Treasury Officer, Nalbari, also apprised the court that an amount of rupees 29,413 paid to the petitioner for the period from 13/03/2014 area amount of women's section to 31/01/2015 wide voucher number 2202/0207 dated 18/02/2022. Against the bill number pura capital oblique 202122 oblique BELEF 002/00250 dated 15/02/2022. In view of the above, as the respondent will comply with, no such contempt, the petition stands rejected. Notice of contempt issued of the respondents of the respondent authorities will on notice. Notice of such and such. So on 26/10/2021 is hereby recalled. Communication of the such and such we place it up to the record of writing mistake. Matter pertains to non-compliance of the order dated 09/11/2018, passed in WPC number 7638/2018. No representation on behalf of the petitioners on call. No name of two councils have been reflected in the cause list. Even on last occasion, the petitioner remain unrepresented. Petition stand dismissed. Notice of contempt. So earlier, respondent of the reason 31/10/2019 recalled.
Praise the Lordship. Lordship, matter has already become infructuous. So your Lordship may kindly close the petition.
What's your good name, ma'am?
S.R. Majabhi.
Matter pertains to non-compliance of the order dated 12/02/2018. Passed in WPC number 686/2018. Grant counsel for the petitioner, such and such, placed before the submitted that during pendency of the such and such have complied with the said order. And we have there is no such contempt on the part of the respondent authorities under the contents of that court circuit. Notice of contempt issued earlier on 02/08/2019. Recall.
Respondent number 2 has to submit affidavit, but till date, no affidavit has been filed. One is also filed.
Second. Speaking of the first two, which one of it.
Who is appearing for the respondents?
Lordship, I am for the respondent number 1, Lordship. I have filed our affidavit.
What happened with the representation of the petitioner?
Lordship, I have complied our part. I was sending to the director secondary direction with respondent number 2, Lordship.
When?
annexure in affidavit. In opposition, Lordship, annexure at page 55, Lordship. Along with Lordship, minus of the DSC meeting, Lordship.
The case of the petitioner was for the 2011 Act.
Yes, Lordship.
And because at that point of time it was on the basis of seniority, the case of the petitioner could not be considered. Now, what decision you have taken?
Lordship, I am not in the.
The inspector of schools, Sagar, has forwarded the case to the Director of Secondary Education, Assam, on the basis of the report of the district scrutiny committee. Do the needful, that's all.
I am not in the post now.
The inspector of schools. By its communication dated 16 09/2019 submitted recommendation of the district scrutiny committee within bracket secondary comma Nagaon held on 07/09/2019 pertaining to its decision for provincialization of service of the petitioner, which is now pending before the Director of Secondary Education Assam, being the chairman of the state level selection committee. And therefore, on the next date fixed, Director of Secondary Education shall apprise the court about the outcome of its decision of the state level selection committee, SLSA. But say recommendation of the DSC within the secondary Nagaon placed on 30th March 20.
No, it's not. Order illustrable from page 12, madam.
Still pending.
Lordship. This is the second contempt petition order. Earlier it was closed on the ground that the BTC had no information. Thereafter, the petitioner has filed a representation before the BTC. And even then they did not comply the order, madam. Judgment is specific. Lordship, when relevant portion, page 15. Judgment.
Why you have filed it before the headmaster?
Earlier it was headmaster was informed. Thereafter, my lord.
Now the school is under which, whether under BTC or under
BTC matter, because the lordship went page 21.
Where is your application before the BTC authorities?
Page 21. Dated 8/4/19. 22, lordship will find the date is there.
Pursuant to the order, Mr. Esma. Pursuant to the order dated 23/04/2015, passed in WPC number 3625/2007. The petitioner submitted his application before the Director of Education BTC Kokrajhar on 08/04/2019. Since the respondent authority is not complied with the said direction of the court dated such and such, petitioner has filed this contempt petition. Do you want this? We'll pass this order. Period. List on 1st March. reflecting the name of standing council BTC in the public for the under the respondent conference. Day after tomorrow. Always. Mr. Chaudhary, you appear for BTC?
Yes, my lord.
Then no problem. We could do. Petitioner shall serve on the next date fixed. The Director of Education BTC shall apprise the court about the status of the representation of the petitioner dated 08/04/2019. Mr. Nath.
I'll furnish
Survey copy of
I'll furnish for madam.
survey copy of the order passed by the court and also your representation. Mr. Chaudhary.
I'll furnish the entire copy.
Less than 31st of March.
Obliged.
May it be please your lordship, may lordship 1 week time may be allowed to file impletement petition lordship. Impletement petition file. Secondary.
Marketing schedule to show us. Marketing schedule is clear. Statement.
Mr. Mazumdar.
Representation. They were required to file representations. No statement saying that they have filed the representations. Statement in they have filed the representation.
Difficulties, an interim order was passed on zero two 2015. And in the final order,
We should not disturb them. That would perhaps be of no consequence. Perhaps, my lord, why I say so. Their claim was to provincialization.
no, that is fine.
So
The
if
thing
you
is
find
this,
them not to be entitled,
if they are entitled to fine, if they are not entitled, there are also the school, because school will be provincialized.
Yes.
Now entire building and then everything will be taken over by the government. In that circumstances, what will happen?
if they are entitled to provincialization under the 17 Act also, then they would not be entitled to anything.
But because of disorder of the court.
No, if their services in the unprovincialized stage remains protected, not in the provincialized state. And Lordship would have page 8, para 5, sorry, madam, page 9, para 6. They have given a copy of the orders to the respondents. There was a consequential, there was a precondition for us to consider only if they filed any representations, not a statement in the entire contempt petition that they had filed any representation before us, because they were required to give us detailed representation on which we were required to pass orders, not a sentence anywhere. Para 6, they gave us a copy of the order. Para 7, we did not take steps.
Petitioners on the next date fixed shall apprise the court as to when it's submitted. Detailed representations individually. In terms of the order dated 17/07/2019, first in WBC number 446/2015, based on 27th of March.
Actually, in this matter, dice code was allocated, and unfortunately, in the financial assistance order, the word Balika was omitted from the name of the school. Now, I pray before your lordship to paragraph 10 of my petition. May I read?
Now, just a minute.
Before going to merit of the case, Lordship, may I submit one thing, Lordship? Lordship, can you see paragraph number 2, Lordship? Lordship, that the petitioner said that the petitioner number 1 and 2 are headmaster and assistant teacher, respectively, so and so school. Lordship, then Dokhin Amingarh Janarjay Balika School was established so and so. Then, Lordship, the petitioner number 1 joined as headmaster in the Efforts School on 3/1/2007. Lordship, if it is correct, Lordship, then Lordship, record reveals another thing, Lordship. I have filed affidavit in opposition, Lordship, in this school, government has, Lordship, kindly see my affidavit in opposition, page number 10. It is a direct order of the government, Lordship. Headmaster is another person, Lordship, Abdul Lordship. If headmaster, 2 headmaster cannot be in a school, Lordship, and he cannot be a headmaster, he says that till today he is headmaster. Lordship, in affidavit in opposition, I have given the order of the elementary education. He has joined in 2003. Lordship, 2 headmaster in a school, then Lordship, can we say affidavit of opposition? He has to make party, otherwise, Lordship, it has to be the original headmaster. If it is headmaster, then the order itself, he has silent, itself also reveals, Lordship, and page number, Lordship, 65. The Act of Elementary Education, Lordship. It also said that Abdul Rafiq was appointed as head teacher. Page number 63 and 64 by Nicola, Lordship. So, as a government has to establish who is the original headmaster. And in this order, Lordship, he says that he was age of 16, who is claiming as a headmaster. So his paper was rejected. So at this, so Lordship, in this account, his petition may be dismissed. Lordship, at least he is not entitled, Lordship. If it is headmaster, I have nothing to say. Lordship, it has to prove, Lordship. If he has given this statement, paragraph number 2. He is the headmaster. Then who is?
Now, in this case, my learned friend is appearing for the assistant master,
Lordship,
and he is
I have
praying
given
for dismissing of the case.
Yes, by filing affidavit of opposition. That's my. Because facts
And,
has to be.
Lordship,
Proper facts
most
has to be
respectfully, in paragraph 10 of my petition, may I read, Lordship?
Mr. Who is appearing for elementary?
No.
Majumdar, we have a copy of the repetition.
No, they have taken one from.
Just come to page number 65. This is under challenge.
465.
That's an order of the Director of Elementary Education. That's all.
Escape me.
You have to go to the records
62
and
on
find.
mine.
Oh, it may be in your 62, but it is an order of 12 February 2017.
Yes, yes, my lord.
Just find out, that much will do.
No, it's an order of 12th of February 2017.
That is under challenge.
My lord, yes.
Nothing much to do. When? Get the records and verify and place it, finish.
In that regard,
Nothing much to do.
Lordship, may I please? In that regard, the order dated 25/11/2020, based upon the submission of both the sides, that order was passed. I don't remember.
Which order was passed?
Dated 25/11/2020, based on the submissions of both the sides, because certain anomalies were detected by the Honorable Court.
Mr. Chaudhary, you are representing SSA. Details. What are the details? That's all. When fixing it on a date, give us a date so that 28th of March. 28th of March. Tell us. And he makes it fixed. The authorities in the Director of Elementary Education Assam and the SSA Assam, represented by Mr. Majumdar, and the Council Department of School Education and Mr. B. Chaudhary, shall place the relevant records and the entertainment of
letter order dated
salary.
Oh.
They will by the respondent authorities. Mr. Dekha,
Respondents are directed to get
28.
Yes. Here also respondents are directed to get instruction on the appointment of the petitioner in compliance of the earlier honorable court's direction and passed in the revision as well as in the contempt case. Let me kindly see annexure 11 page 32. Already select list published. Thereafter, Lordship, they have passed the order to avoid the contempt proceeding, but till that the appointment order is not issued. There is an interim order is still continue, Lordship. Let you kindly see page 32 annexure 11. 6 years have been gone by, Lordship. The state level selection committee, they have published this select list, page 1132, in compliance.
What is the reason, madam, why appointment orders have not been issued? There is something, any hindrance?
The day shown that now they are asking for a copy of the repetition after 7 years.
One communication I have, my lord.
Then lots of annexure 12, page 33. Select list published.
See, this is the difficulty.
My lord.
This is, or you are appearing for director or you are appearing for the government.
My lord.
You have to manage both the sides, not only one side. Likha. Pursuant to the direction of the court, first in WPC number 20 of 2017, within bracket, Puran Chandra Boro and others versus State of Assam and others, as well as WPC number 21 of 2017, within bracket, Hare Krishna Das and others versus State of Assam and others. The state level selection committee
My lord,
represented by the Director of Elementary Education Assam as chairman,
I say,
Deputy Director Elementary Education as member, and Deputy Director Elementary Education as member secretary in its meeting held on 07/03/2019. Selected.
may I, my lord? Sorry for interruption. I have received another instruction, my lord. Can I submit now?
Just read it out.
Yes, my lord. With reference to the subject cited above, I am directed. This is Narayan Kaur IS, Secretary to the Government of Assam, to the Director, Elementary Education, my lord. With the, I am directed to convey the approval of Governor of Assam for filling up 5 posts, 5 sanction vacant posts of grade 4 by way of appointment of the forwarding candidates in upper primary school under Kamrup district in compliance of Honorable Guwahati High Court order that is so and so, my lord. Already, my lord.
When this order was issued?
20th February 2023, my lord.
20.
My lord.
Lekha, Katidia Agrawala. Ms. Anfukang, Sending Council, Department of School, within bracket Elementary Education. On specific instructions submitted that the state government in the Elementary Education Department have approved the name of the petitioners.
Yes, ma'am.
For their appointment as grade 4 chowkidars in Kamrup district or Kamrup?
Yes,
Rural?
Kamrup Rural Road.
In the Kamrup district. In provincialized upper primary schools, grade 4 chowkidar grade 4 chowkidar upper in the provincialized upper primary schools in the district of Kamrup. In view of the above, the authorities in the state government in the elementary education as well as the Director of Elementary Education Assam shall place the relevant orders of appointment of the petitioners on the next date. List on 22nd of March.
Right. One prayer, I think 48, this 80 years petitioners, so they read in 2005.
Hold on, we're going, we're not finishing it. Next.
As per the order dated 1/9/2022, we have taken step upon respondent 7 through paper publication in item 44. We have also filed an additional affidavit on 28/9/22. We have annexed it, page number 48. Summary of question and 49 the sentence.
When such paper publication was made? On which date?
On 23/9/2022, from our next question. And the Sentinel on 27/9/2022.
Direction was given for within one in Assamese and the one in the Bengali, where in the English.
Yeah.
Pursuant to the order dated 01/09/2022, the petitioner issued notice upon the respondent number 7 by issuing necessary paper publication. What is the name of the newspaper? Samoik Prasanga. Published from Silsar district, Kachar on 23/09/2022. As well as English Daily Sentinel, dated 27/09/2022. Anyone appeared?
I'm appearing for
You are appearing for whom?
number 1, 2,
When did you file your affidavit?
and 4.
When you file your affidavit?
Not filed.
Not filed. As such, service of notice is currently respondent with litigation. Notice in this case was issued on 30/08/2019, but the respondent authorities still did have not filed any affidavit in the matter. We are on the part of the respondent authorities to file their affidavit in the matter, but the respondent numbers 1 and 2 on or before 23rd of March 2023. They shall pay an amount of rupees 1 lakh each for the Legal Services Authority, State Legal Service Authority, Assam, and the High Court Legal Service Authority from their own salary. Mr. Sharma, you are also human being. There is a limit. Now, in the other case, notice was issued on 4/4/2018. No affidavit. Tell us what to do. Have you taken steps here in the other case? What about WPC 1939? Same case. Notice. Common order for the bottom to my devices. Placed on 27th of March.
So probably this matter become infractional regarding deputation of gate post for the session 2019-21. Already session is over. In fact, let's say after the interim order from the authority concerned also, they passed an order on 4th of November 2019, whereby the impure order is stayed. In view of this order, matter will be closed. 4/11/2019, passed by the Director of Secondary. So there is no communication between the petitioner and the electors.
What order was filed in 5725? Some order was passed.
Lordship,
That
if
order-
you hear, Lordship, impune order is 19-9.
But that order was passed by the director pursuant to an order of the court dated 14/8/2019. Some order was passed. We do not know what order was passed.
The 14/8 is the fourth order, Lordship. The 14/8 order is, Lordship, find at page 24. This was issued in the filed by another candidate, Baharul Islam, 14/8/2019. Thereafter, this impugn order issued on 19/9/2019, whereby my BH deputation order is cancelled. But after approaching the authority by the petitioner, this order was stayed on 19/9/2019. Ultimately, the order of November 2019 that was issued. And in the meantime, this was for the session 2019 and 21. Already completed the course.
Heard Mr. Edeka, counsel appearing for the petitioner. And Mr. U. Sharma, standing counsel, Secondary Department of School Education. Matter pertains to allowing the petitioner to complete the B.Ed course for the session 2019-21. During pendency of this petition, the said period of period for the session 2019-2021 of B.Ed courses, the B.Ed course for the session 2019-21 on deputation. The said period of such and such is already over in view of the above the said petition. And Froxos stands rejected. The interim order passed earlier on.
On Lordship, 26th of
26/09/2019,
Yes.
accordingly stands packeted.
My lord, the present petitioners were the retired teachers of Kokrajhar government college. Now, as per the government scheme, my lord, they have returned their amount of GPF share, etc. That may be seen page 28.
Just a minute.
Okay.
The Director of Higher Education Assam, by an order dated 13/07/2016, pursuant to the orders passed in WPC number 136/2010, rejected sanction an amount of rupees 3,60,000 for payment of gratuity to the petitioners at the rate of rupees 72,000 each. Accordingly, bills in that regard was prepared and submitted to the Treasury Office, the school, for drawal and disbursement of the amount into the personal account of the petitioners. In the said order, the 13/07/2016, the Director of Higher Education observed that the petitioners are not entitled for leave encasement, as there was no earned leave to the college teachers served prior to provincialization of the services of the employees on 01/02/2005. The said order is in challenge in the connected WPC number 620/2018. By this application, the applicants / read petitioners of WPC number 620/2018 prayed for early hearing of the said read petition, stating that the petitioners retired from service long back and they are quite old persons. After hearing the learned counsel for the parties and such, release this matter for hearing on 21st of March.
As fixed,
On the
I
said
think.
date, the respondents in the second higher education department shall place the relevant records in which the impugned order is the 13/07/2016 was passed by the Director of Higher Education. sir.
Published.
My lord, this I is for my lord on behalf of petitioner number 3, my lord. He is my lord not interested to pursue the case. That is my lord. So we have filed this I for striking out his name, my lord.
The present applicant has read petitioner number 3. While the connected WPC number 677/2015. Praying for setting aside the order dated 22/09/2015 passed by the Assam Administrative Tribunal in case number, where is that? 1888/2015 on 22/09/2015, as well as for a direction to the respondent authorities to invoke the provisions of clause 8.6.0 of UGC notification to count their seniority from the date of their appointment on ad hoc basis under regulation 3F of APSC within bracket limitation and functions bracket close regulations 1951. By this application, said petitioner number 3 of WPC number 677/2017.
15, my lord.
Sorry, 2015. Have prayed for striking out his name from WPC number such and such. As is not interested to pursue the said writ petition further. To which the counsel for the respondents in the higher education department have no objection. Accordingly, this interrogatory application is allowed. The name of the applicant / petitioner number 3 in the residue deleted from the cost title. Maybe strike off from the cost title. Next, main great petition of in view of the order passed today, connected ISC 454/2023. The name of the petition number 3 may be struck off from the cost title. Registry shall accordingly do the needful by using the numbers of the petitioners, new serial numbers to the petitions.
Bless.